The train was a TGV traveling at 310 kilometers per hour when Dominic Haas pushed me off the platform at Lyon Part Dieu station on a Thursday evening in October. This is a fact. I know the speed because I have since looked it up because I am the kind of person who looks things up. Because I spent 34 years as a civil litigation attorney in Basel, and knowing the precise facts of a situation is the discipline on which I have built my professional life and my private survival. 310 kilometers per hour. I had approximately 1 second between the moment I felt his hands on my back and the moment I needed to have already done the only thing that was going to keep me alive. What I did was fall correctly. This is not a skill I was taught. It is a skill I acquired in the specific way that certain skills are acquired in genuine emergencies, which is to say that my body decided what to do before my mind had time to refuse it. I had been falling a long time before I understood I was falling, and by the time I understood, I had already gone sideways over the platform edge, rather than forward onto the tracks. And instead of landing on the rail itself, I had landed in the maintenance channel between the two track beds, the shallow concrete trough that runs between the rails, and that exists I later learned from the SNCF maintenance engineer who interviewed me in the hospital, for exactly the purpose it served that evening, which is to say, as the 3 inches of clearance between the underside of a passing train and the concrete floor of the track bed. I want to tell you something about that 1 second, not because I am certain I can describe it accurately, but because I have tried many times in the months since to understand what happened in it, and the trying has produced something that feels important. In 34 years of civil litigation, I have prepared and presented arguments involving the analysis of time intervals in which decisions were made or not made, actions were taken or not taken, and the legal and factual consequences of those decisions and actions were determined. I have sat with juries and walked them through reconstructions of events that lasted 3 seconds, 5 seconds, 45 seconds, and that required them to understand the significance of each component of those intervals. I have always understood intellectually that very short intervals can contain very significant things. What I understood in a different way after October is that the shortest significant interval I had ever worked with professionally was still long by the standard of what the body can do when it has no time to consult the mind. The body has its own logic. It has its own response architecture that exists below and prior to the architecture of deliberate decision. The fall to the side rather than forward was not a decision I made. It was a response the body executed before the mind had framed the question. 34 years of precise professional thinking had not produced the outcome. The outcome was produced by something that had been in my body before I had any profession at all. I find I think about this regularly. I think it is connected to what Dr. Kramer helped me understand about the relationship between precision and intuition, and about the things that the professional discipline protects and the things it cannot reach. The precision is mine. The fall was also mine. They are not the same kind of mine. The train passed over me in approximately 4 seconds. The noise was the loudest thing I have ever heard in my life. I lay in the concrete channel with my hands pressed flat against the floor and my face turned sideways against the concrete, and I felt the displacement of air from the train passing above me like a physical blow, and I waited. 4 seconds is both an extremely long time and an extremely short time depending on what is happening during those 4 seconds. When the train had passed, I lay in the channel for a further 6 or 7 seconds, not because I was incapacitated, but because the professional part of my brain, the part that had been processing and organizing information for 34 years, was conducting a rapid inventory of the available facts. Fact 1, I was alive. Fact 2, Dominic Haas had pushed me off the platform. Fact 3, I had seen his face in the moment immediately before I went over the edge, and his face had an expression on it that I recognized the specific expression of a person who is committed to something and is watching it execute. Fact 4. My daughter Isabel had been standing beside him. I lay in the track channel for 6 or 7 seconds, and I let these facts arrange themselves in the order they were going to need to be in. Then I got up. I climbed back onto the platform from the end of the channel, where the track dipped below the platform edge, and there was a maintenance access point. My suit was ruined. There was concrete dust on my face, and my hands were bleeding from where I had pressed them against the rough floor of the channel. Several people on the platform were in various states of alarm, some pointing at me, some on their phones, some simply staring. I stood on the platform and I looked for Dominic and Isabel. They were not there. They had already gone. I noted this. I noted the time on the station clock, which read 1947. I noted the direction they would have had to take to reach the exit. I noted the faces of the people who had seen what happened. I noted the position of the security cameras above the platform entrance, the one that covered the section of platform where I had been standing, and the one that covered the escalators leading down from the mezzanine level. Then I sat down on a platform bench and waited for the station security staff to arrive, which they did in approximately 90 seconds. My name is Conrad Westerberg. I am 63 years old. I was born in Basel in 1961, the son of a pharmacist and a secondary school teacher, and I grew up in the specific context of a Swiss-German family of the kind that values precision and reliability and the careful management of obligations the way other families value warmth or ambition. I studied law at the University of Basel and then at the LSE in London for a year, and I returned to Basel to join a civil litigation firm where I worked for 8 years before founding my own practice, Westerberg & Partner, in 1994. We have 41 attorneys on staff now, and offices in Basel, Zurich, and since 2019, Lyon, which is where I was on that October evening, attending a client meeting that had concluded 3 hours earlier than expected, and which is why I had been at Lyon Part Dieu station at 1947 instead of at the restaurant where I had arranged to meet Dominic and Isabel for dinner at 8 o'clock. I had arrived at the station early because I intended to take the earlier train and surprise them by arriving at the restaurant before they did. This is an important fact, one I have returned to many times in the months since. If I had stayed for the dinner as planned, if I had not been early, if I had not been standing on that specific section of the platform, if the maintenance channel had been 10 millimeters shallower. I have spent 34 years in civil litigation, and I know better than most people how precisely balanced the facts of a catastrophe can be. How many small decisions and coincidences align to produce an outcome, and how differently they could have aligned to produce a different one. I was alive because I was early, because I fell sideways, and because the channel was deep enough. Let me tell you about Dominic Haas, before I tell you what happened after the platform. He deserves an accurate description, because the accurate description is necessary for understanding both what happened and why the subsequent events unfolded in the way they did. Dominic was 39 years old, a financial advisor with a firm in Zurich that managed private wealth for high net worth clients across the German-speaking region of Switzerland and southern Germany. He was tall and well-built in the specific way of men who exercise regularly as a professional discipline, rather than from any genuine relationship with physical activity. And he had the face of a person who had understood at an early age that his face was an asset, and who had invested accordingly in its maintenance. He dressed well. He spoke well. He had the particular social fluency of someone who has learned to mirror the person in front of him to reflect their interests and their humor back at them with enough added value to pass as intelligence. I had seen this quality in many people over 34 years of legal practice, and I had learned to identify it relatively quickly as what it was, which was technique rather than substance. What I had not identified quickly enough in the case of Dominic Haas was the degree to which the technique was the entirety of the man. He had met Isabel 4 years ago at a professional dinner in Zurich. She was a partner in an architectural firm, and she was at the dinner because one of the firm's clients had invited her. He was at the dinner because one of his clients had invited him. They had been seated at the same table, and he had, by Isabel's account as she gave it to me at the time, been attentive and funny and interested in her work in a way that she described as refreshing. They had dated for 14 months and married in a ceremony in Geneva that had been by any objective assessment a beautiful event, and for which I had paid the majority of the costs because Isabel asked me to, and because Isabel was my daughter, and because I had believed at the time that she had found someone worth the investment. I want to be fair to myself in this account, and fairness requires me to acknowledge that I had reservations about Dominic from the beginning that I did not act on. The reservations were professional rather than personal, which is to say they were about the quality of his work rather than the quality of his character. And they manifested as a mild and consistent sense that the intelligence he presented to the world was not entirely his own. I had dinner with the two of them 6 times in the period between their meeting and their wedding, and on each occasion Dominic had participated in the conversation with apparent engagement, and on each occasion, if I traced the conversation backward afterward, I could find the point at which his contribution had shifted from participation to performance. He agreed with the last person who had spoken. He escalated the emotional temperature of any point that seemed to be resonating with the group. He pivoted away from specific questions with a smoothness that most people read as confidence, and that I recognized after the second dinner as evasion. I did not say any of this to Isabel. I am not certain I should have said it, though I have thought about this question a great deal since October. Isabel was 35 years old and an accomplished professional, and my daughter, and she had the right to make her own assessment of the person she was marrying. What I had were professional instincts about a behavioral pattern that I had no specific evidence to attach to a specific harm. I kept my reservations to myself. I should also tell you about my firm, because the firm is central to understanding what Dominic had in mind. Westerberg and Partner had, in the course of 34 years, accumulated the specific kind of value that accrues to a well-run professional services firm over a long period, a reputation in the Swiss civil litigation market that was based on a record of outcomes rather than on marketing, a client roster that included several very significant private banking institutions and pharmaceutical companies and family offices, and an asset base that included the office properties in Basel and Zurich, the participation in several real estate investment structures that I had entered over the years as a private investor, and a shareholding structure in the firm itself that I had carefully constructed with the assistance of my financial advisor and my estate planning attorney to be both stable and cleanly transferable. The firm's revenue was not publicly known, but it was by the standards of private legal practice in the Swiss market considerable. Dominic had been asking questions about the firm from approximately 18 months into his relationship with Isabel. The questions had been framed as interest, as the natural curiosity of a partner in an intimate relationship about the professional life of the person he was with. He asked about clients, about the structure of the practice, about how succession was handled in professional firms of this type. I had answered these questions in the way I answered most questions about the firm, which is to say, with honesty about the general structure and reticence about the specific details that were not relevant to the conversation. I had not at the time understood the questions as the assessment they were. I understood them now. What I understood now, lying in the hospital in Lyon on the night after the platform, my hands bandaged and my ribs bruised from the impact with the channel wall, and my mind moving through everything with the speed and precision that it moves through things, when I have just survived an attempt on my life and have approximately 12 hours before the people responsible learn that I survived it? Was this Dominic had determined at some point in the previous year that the timeline of natural inheritance was not acceptable to him, and that the most reliable solution to this problem was my death before I had the opportunity to alter the estate structure I had established? The station's security had taken a statement from me on the platform. I had been calm and precise, and I had given them Dominic's full name, his address in Zurich, and a description of the event that was accurate, and that I had been careful to phrase in terms that would be useful in a subsequent legal proceeding. The SNCF staff had reviewed the security camera footage, which had clearly captured the moment of the push, and had called the Lyon police who had arrived and taken a further statement and told me they would need to view the footage formally and that I should remain available. I had given them my card, both the Lyon office card and the Basel office card. I had told them that I was a practicing attorney with experience in criminal procedure and that I understood my obligations and would cooperate fully. The detective I spoke to, a woman named Inspector Favre, who had the specific, efficient quality of someone who has seen many things and manages them competently, had looked at me with a slight adjustment of expression that I recognized as reappraisal. She said, "Monsieur Westerberg, you are very calm for a man who has just been pushed onto train tracks." I said, "I am a lawyer. We are trained to be calm in difficult situations." This was true, and it was also not the whole truth. The whole truth was that I was calm, because the moment I had climbed back onto that platform and found that Dominic and Isabel had already gone, I had understood that I had, for the first time in this situation, a decisive advantage, and that the management of that advantage required exactly the quality of calm that I was projecting. They did not know I had survived. Let me say that again, because it is the fact on which everything subsequently depended. Dominic had pushed me off the platform and had immediately left the station with Isabel. He had not waited to confirm the outcome. He had assumed the outcome. The train had been passing through at that moment a TGV at 310 kilometers per hour, and the calculation he had made. The calculation that had presumably been made in advance with the specific planning that a person does when they are committing to something this serious was that the outcome was certain. He had left because he did not need to stay. He had pushed a man onto the tracks in front of a high-speed train, and he was confident he had done what he had come to do. He was wrong, and he did not know he was wrong. And that specific window of time between his departure from the station and the moment when he would find out I had survived was the most valuable resource I had ever possessed. I called my lawyer, not my own office, which would have been inappropriate and complicated, but my personal attorney, a woman named Claudia Reinhardt in Basel, who had handled my estate planning and the structural arrangements of the firm for 15 years, and who was without qualification the most practically intelligent person I knew in the Swiss legal ecosystem. She answered on the second ring. It was 11 o'clock in the evening. I said, "Claudia, I need 2 hours of your time right now. I need you to listen to everything I tell you, and then I need you to tell me the sequence of actions I should take and the order in which to take them." She said, "Are you in danger?" I said, "Not at this precise moment." She said, "Then tell me." I told her everything from the beginning with the precision and completeness of someone who has spent 34 years preparing witness statements. She listened without interrupting until I had finished. Then she was silent for approximately 10 seconds. Then she said, "Conrad, you understand that the window you have is extremely narrow." I said, "Yes." She said, "What you need to do in the next 6 hours will determine whether this is a criminal matter that proceeds correctly or a civil disaster that they have a chance of muddying." I said, "I know." She said, "I am going to need to wake up some people." I said, "Wake them up." I want to describe what those 6 hours felt like from inside them, because the clinical account I have given above does not capture the full reality of working through the night in a Leon hotel room with bandaged hands and bruised ribs, while your son-in-law is asleep somewhere in the city, believing he has killed you. The room was a standard hotel room, comfortable and anonymous. I had ordered tea from room service, and it sat on the desk beside my laptop, getting cold while I worked. My hands hurt in a specific way that bruised hands hurt a deep ache with sharper pain when I applied pressure, and applying pressure was exactly what typing required. I did not take the painkillers the hospital had given me because I needed my mind at full capacity, and I did not trust analgesics in combination with the specific concentration required for what I was doing. The documentation file I had been building since August was on the secure server. I accessed it, and I began the work of transforming it from a precautionary file into a prosecution-ready file, which meant organizing the material in the specific sequence that a prosecutor would need, cross-referencing each item with the relevant legal framework, and annotating each item with the factual claim it was intended to support. This is the work I have done in civil litigation for 34 years, and I can do it under almost any conditions. I can do it with bruised ribs and bandaged hands at midnight in a hotel room in Lyon, the evening after someone has tried to kill me. This is not a boast. It is a description of what the professional discipline means when tested at its absolute limit. Claudia was working simultaneously from Basel. We spoke 5 times during those 6 hours, each conversation brief and specific, each one advancing the parallel legal actions she was coordinating. Between those calls, I organized and annotated and built the file. The desk lamp threw a small circle of light across the keyboard and the legal pad where I was making notes by hand, because certain kinds of thinking happened better on paper. The city outside was quiet. Lyon in October at midnight has the specific quiet of a city that has completed its evening and not yet begun its morning, and it was a useful quiet. The quiet in which the work I needed to do was the only sound. At 3 a.m, I made a cup of tea from the room service items on the desk, and I sat back in the chair for 5 minutes. 5 minutes exactly. I have a habit developed over 34 years of building 5-minute rests into long work sessions because the productivity curve in sustained concentration has a shape that rewards periodic disengagement. I sat back and I looked at the ceiling of the hotel room and I thought about the platform. Not the falling. The moment before the falling. The specific 3-second sequence in which I had been standing on the platform, waiting for my train, and had heard a voice behind me that I recognized as Dominic's, saying my name, and had begun to turn and had felt the push. 3 seconds. In 3 seconds, a man can destroy 40 years of careful construction or fail to do so depending on which side of the equation he is standing on. I had been on the right side of the equation. That was luck, not merit, and I want to be honest about that. The channel had been deep enough by approximately 3 inches. If it had been 3 inches shallower, no amount of professional discipline would have produced the outcome I was sitting in that hotel room pursuing. I thought about this for 5 minutes. Then I went back to work. What happened in the next 6 hours is, in retrospect, the most efficient period of work I have ever engaged in, and I have engaged in many efficient periods of work. Claudia called the Basel prosecutor's office. She called the FINMA contact who handled financial advisor licensing matters. She called an attorney in Zurich she trusted absolutely who specialized in financial fraud. She called my estate planning advisor at home. And while she was making these calls, I was in my Lyon hotel room with my laptop and my secure file access, and I was building the documentation file that I had in fact been building for 3 months since a conversation I had overheard in the Basel office in July that had told me something was wrong without telling me precisely what. I need to go back to July because the October platform was not the beginning of this story. It was the end of one chapter of it. In July, I had been in Basel on a Tuesday afternoon earlier than expected from a court appearance that had concluded quickly, and I had entered the office through the side stairwell rather than the main entrance because I had a package of documents to deliver to the filing room on the second floor. The filing room shared a wall with the small conference room adjacent to my office, a room that I used occasionally for internal meetings. As I passed the filing room door on my way to the stairwell, I heard voices through the wall. One was Dominic's. The other I did not recognize. I stopped. The conversation I could hear in fragments through the wall was in German. The Basel German of two men who were comfortable with each other and not making any effort to be discreet. I could not make out full sentences. What I could make out was the register of the conversation, which was the register of professional consultation. The words I caught in the brief period before I consciously decided what to do were inheritance timeline assessment and the phrase which cannot be verified until. That last phrase, which cannot be verified until, arrived through the wall in the specific tone of someone acknowledging a contingency in a plan. The kind of acknowledgement that happens in a planning conversation rather than in a casual one. I did not go into this conference room. I went to the filing room, deposited my documents, and went back downstairs to the main entrance and re-entered through the front door with sufficient noise to announce my presence. By the time I reached the second floor, the conference room was empty. The chairs had been pushed in. The table surface was clear. No coffee cups, no papers. Whatever they had brought with them, they had taken with them. I noted the time 3:47 in the afternoon. I noted that my calendar showed no meeting scheduled for the conference room. I noted that Dominic had no client business in the Basel office on that particular Tuesday. I called the front desk and asked who had signed in with a visitor pass in the last 2 hours. The receptionist checked the log and told me a man named Franz Becker had signed in at 3:15, accompanying Dominic Haas, who had used his partner family pass. A partner family pass was the identification card I had issued to Isabel when she became my daughter-in-law, giving her, and by extension, her household access to the building for personal visits. It had never been intended as access for professional meetings. I did not know a Franz Becker. I looked up the name in the Swiss commercial register that evening and found the notary. In the weeks that followed, I moved carefully. I want to describe the experience of those weeks because they have a specific quality that is difficult to render accurately, but that matters for understanding what the platform ultimately meant. I was in my ordinary life, attending to my ordinary professional obligations, having ordinary conversations with colleagues and clients and opposing counsel. And simultaneously, I was building a parallel understanding of my situation that I could not share with anyone around me because the people around me were either potentially compromised or unaware of the threat and sharing information about a threat. Before you have a complete picture of it is one of the most common ways to warn the threatening party that they have been identified. I was in court on 2 mornings in August, arguing a pharmaceutical liability matter that I had been working on for 14 months. The work required the same quality of attention it had always required. I was also simultaneously in the reading room of the Basel Commercial Registry for a total of 4 hours across 3 visits, reviewing the professional history of Franz Becker and the corporate structure of 2 entities whose names had appeared in a document Dominic had left visible on his screen during a joint calendar meeting in early August, visible for approximately 8 seconds before he closed the window long enough for me to read and retain the company names, which is a skill that is not formally taught in legal training, but that develops naturally after enough years of reading documents quickly. I commissioned the background check through an investigator named Werner Fry, who had done work for the firm on financial fraud matters and whose discretion was absolute. I gave him Dominic's full name and professional history and asked for a complete picture of his financial situation over the preceding 24 months. Werner delivered his report in 10 days. The debt was documented there. The private investment positions, the scale of the loss. 3.4 million Swiss francs in losses from leveraged positions in a credit instrument that had moved against him in the spring volatility. The positions were held through a personal investment account at a private bank, not through his firm, and they were therefore not visible in any professional registration. They were visible because Werner was very good at his work. 3.4 million. That was the number that had created the acceleration of the timeline. The inheritance had become urgent not because Dominic was impatient, but because he was indebted, and the debt was the kind of debt that does not wait for natural timelines. I also found during this period that Dominic had made contact with a doctor in private practice in Geneva, whose online profile described his specialization as forensic psychiatry, with experience in capacity assessments and legal competency evaluations. A forensic psychiatrist, capacity assessments, legal competency evaluations. I understood what they were planning. They were planning to have me assessed as legally incompetent to use that assessment to obtain conservatorship or power of attorney over my affairs, and to use that control to transfer assets before my natural death made the inheritance straightforward. It was a sophisticated version of the kind of scheme I had seen in estate litigation cases 3 times in my career, and it was more sophisticated than those 3 cases because Dominic had access to my professional world, to the people in it, to the vocabulary and the procedural knowledge required to make the scheme at least superficially plausible. What he had apparently not accounted for was that the person whose competency he was planning to challenge was the person who had built the firm that had litigated those 3 cases. I began in August to prepare a counter-documentation file, not a defensive file, an offensive one. I took the posture of a man who has identified an incoming threat and who has the professional capacity to respond to it comprehensively, which is precisely what I was. I documented the visitor log entries and the calendar data. I documented the expense report. I commissioned, through a trusted investigator I had used for commercial fraud matters, a background check on Dominic's financial situation that revealed something I had not known. He had accumulated significant personal debt over the previous 18 months, the source of which was a series of investment positions he had taken in his own right outside his firm, positions that had moved badly against him in a volatile year in the leveraged credit markets. The debt was private, not publicly registered, but it was real and it was substantial, and it provided the motive for an acceleration of the timeline that I had been, until that investigation, still treating as somewhat theoretical. It was not theoretical. The October platform was not theoretical. So, the hotel room in Lyon. 11 o'clock at night. My hands bandaged. The laptop open. Claudia on the phone. The 6 most important hours of my professional life. By 6 in the morning, the following had been accomplished. The Lyon police had formal confirmation from SNCF that the security camera footage clearly showed Dominic Haas pushing me from the platform. Inspector Favre, who had been awake since midnight processing the footage, called me at 5:45 to tell me that an arrest warrant had been issued and that Zurich police had been contacted under the European arrest warrant framework. She asked me again whether I was all right. I told her I was working. She said, "You are a remarkable man, Monsieur Westerberg." I said I am a man who was pushed off a train platform by his son-in-law and who has a 6-hour head start. I intend to use it. Claudia's Zurich contact had by 5 in the morning filed an emergency injunction, freezing all joint financial accounts held by Isabel and Dominic on the grounds that criminal proceedings had been initiated against Dominic for attempted murder, and that the assets in question were potentially subject to proceeds of crime provisions. The injunction was a precautionary measure, and it was granted by the duty judge at 5:17 in the morning because the security camera footage had been transmitted to Zurich court by that point. The FINMA contact had flagged Dominic's professional license as pending review in connection with ongoing criminal proceedings, which meant that he could not execute any financial transactions in his professional capacity until the review was concluded. The estate planning advisor had been woken up, had been briefed by Claudia, and had issued an emergency revocation of the power of attorney instrument that Dominic had apparently, through means that I was still identifying, obtained from my files. The revocation was filed with the relevant registry at 6:03 in the morning. At 6:15, I received a call from Isabel. I watched the phone ring. I let it ring 4 times because I needed to be in exactly the right register when I answered it. Then I picked up. She said, "Papa, thank God. We heard what happened. Are you all right?" Her voice had the quality of a performance that was not quite good enough. The specific quality I had identified in Dominic at those early dinners, technically correct in its components, but structurally unconvincing. I said, "I am alive, Isabel," which I am sure is a relief. A pause. She said, "Of course." "Of course it is. Where are you?" I said, "In Lyon. The police are here. I gave a statement last night." I paused. There is security camera footage of the platform, Isabel. Silence. Absolute silence on the line for approximately 4 seconds. I said I would like you to come to Lyon this morning. I would like to speak to you before you speak to anyone else. She said in a voice that had changed quality entirely from the opening register, "Papa, I think I need to call a lawyer." I said, "That would be very wise. Please call one who is not connected to Dominic." The arrest happened at 7:42 in the morning at the apartment in Zurich. I know the time because Inspector Favre sent me a message at 7:45 that read simply, "Zurich confirms. He is in custody." I sat in my hotel room with this message on my phone for a long time. The Lyon morning was happening outside the city, making its sounds. The light coming through the curtains with the specific quality of French October morning light that has nothing in it of summer and everything in it of the year, turning toward its end. I had survived. Dominic was in custody. The injunctions were in place. The documentation file was with Claudia. The advantage I had had 6 hours to build was now structural rather than circumstantial. I ordered breakfast from room service. I ate it at the desk while continuing to organize my notes. I called my assistant in Basel and told her I would not be in the office for the remainder of the week. I called the partner managing the Lyon office and briefed him on the relevant elements, maintaining the same clinical register I had used for Inspector Favre. Then I called my doctor in Basel because my ribs were considerably more painful than they had been at midnight, and I wanted to know whether I should be concerned. He told me that bruised ribs were painful but not dangerous, and that I should rest. I told him I would rest on the train back to Basel. He said I should consider the possibility that I was in shock. I said I would consider it. He said, "Conrad, are you actually all right?" I said, "Define all right." He said, "Are you going to be all right?" I said, "Yes. But I am going to need some time to determine what I mean when I say that." The legal proceedings that followed occupied the next 8 months, in the way that complex multi-jurisdictional criminal and civil proceedings occupy time, which is to say completely and with the specific character of a process that moves according to its own logic and cannot be hurried except at great cost to the outcome. Dominic was charged with attempted murder in the French jurisdiction and with financial fraud and abuse of professional position in the Swiss jurisdiction. The French charge proceeded first, and more quickly because the evidence was by any standard conclusive. The security camera footage, 3 witnesses on the platform who made statements, my testimony, A forensic analysis of the camera angle and the physical evidence on the platform and in the channel that established precisely what had happened and precisely where each person had been standing. Dominic's defense was that I had fallen, that the push which was visible on the camera was an attempt to prevent me from falling and had inadvertently contributed to the fall rather than causing it. This defense required the jury to disbelieve the camera footage, 3 witness accounts, my testimony, and the forensic analysis. It was not a defense that was going to succeed, and I believe Dominic's attorney knew it was not going to succeed, but had an obligation to present it because it was the only alternative to a plea, and Dominic refused to plead. The trial took 11 days. I attended every day, which is what you do when you are the victim in a criminal proceeding, and when your presence communicates to the jury the specific message that the person sitting across the courtroom from you has made a mistake in the calculation that their target would not be there to see them held accountable. I sat in the front row of the public gallery each morning in a good suit, and I watched the evidence be presented, and I gave my testimony on the 4th day with the same clinical composure I had maintained since the station platform. The prosecutor, a woman named Maitre Bonnet, who had the specific quality of a person who has seen many things and remains consistently offended by injustice, had prepared an excellent case, and she presented it with the systematic elegance of someone who understands that the facts are the story and does not need to decorate them. The camera footage was shown to the jury on the 2nd day. In the footage, you can see me standing on the platform approximately 2 meters from the platform edge, facing away from the tracks waiting. You can see Dominic approach me from the left. You can see the brief moment when he is directly behind me. You can see the push, which is not an ambiguous image. It is a precise bilateral contact, with both hands to the upper back of a man standing near a train platform. The jury watched it 3 times. On the 3rd viewing, several of them had expressions that I have seen on juries before, the expression of people who have crossed from uncertainty into certainty and find that certainty uncomfortable. The witnesses. 3 people had been on the platform: a woman traveling alone to Paris, who had seen the push from approximately 6 meters away, a couple returning from a business trip who had been standing near the escalator entrance and had seen the immediate aftermath, and a station employee doing a routine platform check who had seen Dominic and Isabel move quickly toward the exit in the seconds after. All 3 gave consistent accounts. The station employee was particularly valuable because she had noted as part of her professional habit the unusual speed with which the 2 people left the platform, a speed that she had at the time associated with distress, and that she had not initially acted on because the platform incident had immediately demanded her attention. Dominic's attorney cross-examined each witness on their sightlines, their emotional state at the time, the distance from the event, the ambient noise that might have affected their perception. The cross-examinations were competent, and they achieved nothing of substance, because the footage was the footage and the footage was unambiguous. My testimony on the 4th day covered the July conversation through the wall, the subsequent 3 months of gathering information, the documentation file, the debt investigation, the Geneva psychiatrist consultation, and the platform itself. I testified for 4 hours in French, which I speak fluently, and I was cross-examined for a further 2 hours. The defense attorney attempted to characterize my investigation of my son-in-law as itself evidence of a paranoid misapprehension of the situation, suggesting that my documentation of his meetings and contacts was the behavior of a person with compromised judgment rather than a person responding rationally to genuine evidence of threat. This was an interesting argument, and it required a careful response. I said, "My professional practice spans 34 years of civil litigation. The competency of my judgment in professional matters is documented in the outcomes of those 34 years. The documentation I compiled regarding my son-in-law's activities was compiled using the same methods I have applied in commercial fraud cases throughout my career. Those methods have been accepted by Swiss courts as producing reliable evidence in multiple proceedings. If there is a question about the quality of my judgment, that question has 34 years of professional record against which it can be assessed. The defense attorney moved to the next question. The forensic analysis was the final element of the prosecution's case. An SNCF forensic engineer and a biomechanics expert from the Université de Lyon had together produced an analysis of the camera footage and the physical evidence on the platform and in the channel that established three things with the precision of scientific testimony. First, that the direction and force of the push was inconsistent with a defensive action to prevent a fall. Second, that the position of Dominic's hands at the moment of contact corresponded to a pushing motion rather than a grabbing or stabilizing motion. And third, that the probability of the described incident being accidental was in the expert's quantified assessment, less than 1% given the totality of the physical evidence. Dominic's attorney had a counter-expert, a biomechanics academic from a university in Marseille, who had reviewed the same footage and produced a report that suggested the analysis was less conclusive than the prosecution had characterized. On cross-examination by Maître Bonnet, the counter-expert acknowledged that his report had been commissioned by the defense, that he had been provided with a specific set of questions to address, rather than being asked to conduct an independent review, and that his conclusion was that the prosecution analysis was less than fully conclusive, rather than that the incident was accidental. The distinction between those two claims was not a small one. What interested me most about the defense was not its content, but its implication. The defense to have any coherence at all required the position that my fall had been accidental, which required the further position that no rational person would push someone off a train platform, which required the further position that there was no motive for the push, which required ignoring the financial fraud investigation entirely. The defense strategy had been constructed to compartmentalize the two proceedings, treating them as unrelated events. This was tactically reasonable from a defense perspective, and it was completely ineffective because the financial fraud evidence and the timing of the push relative to the discovery of that fraud were precisely the story that the prosecution told, and they told it well. Isabelle's position during this period was one of the more painful aspects of an overall painful situation. She had come to Lyon as I had asked, arriving on the Friday morning after the Thursday of the platform, and we had spoken in my hotel room for 3 hours. The conversation had the quality that certain conversations have when they are happening inside a framework of facts that both parties know and that one party has been pretending not to know. She had known that Dominic was planning something. She had not known, she said, that what he was planning was my death. She had believed, or had told herself she believed, that the meetings with the notaries and the attorneys and the psychiatrist were about building a legitimate legal case to challenge what she described as my intransigence about succession planning. I listened to this without arguing with it, because arguing with it in that moment was not what was useful. What was useful was understanding what she actually knew versus what she had chosen not to examine, because those two things required different responses from me and from the legal process. What she knew had emerged over the course of several hours of careful conversation was approximately the following. She knew that Dominic had been speaking to lawyers about obtaining some form of legal control over my affairs. She had participated in one conversation with the Geneva psychiatrist, in which her husband had described my professional behavior as potentially indicating cognitive decline. She had known that Dominic had obtained, through a means she described as a filing error, that she had not investigated a document from my estate files that purported to be a power of attorney instrument. What she claimed she had not known was that any of this would lead to a physical attempt. She claimed she had believed the platform incident was an accident until the police had called her the following morning to inform her that her husband had been arrested and that camera footage existed. I am a trained attorney. I know what I can verify and what I cannot. What I could verify was the documentary and digital evidence. What I could not verify, and what the prosecution ultimately had to take a position on without certainty, was the state of Isabel's knowledge at each stage of the planning. She cooperated fully with the investigation from the beginning. She provided everything the investigators asked for. She testified at Dominic's trial. Her testimony was consistent and detailed, and it supported the prosecution's case at every significant factual point. The sentence. I am going to tell you the sentence first, and then come back to the period between Dominic's arrest and the sentencing, because the sentence is the structural fact around which everything else organizes. Dominic Haas was sentenced to 14 years imprisonment by the Leon Criminal Court with a recommendation of no early release for the first 9 years in view of the premeditated nature of the offense. The financial fraud proceedings in Switzerland were ongoing at the time of the French sentencing and would produce a separate outcome in a separate jurisdiction. He would serve his time in France first. The period between the arrest and the sentencing had the texture of the work it was. I returned to practice in Basel in the second week after Lyon because practicing law was the thing I knew how to do, and because the firm needed me, and because occupying myself with the work of other people's problems was, I had discovered over 34 years, the most reliable method I had for preventing my own problems from becoming the primary environment I inhabited. I worked. I went to the office each morning. I reviewed files, prepared arguments, managed client relationships, had the conversations with my partners about succession and future structure that I had been having intermittently for years, and that the October events had made both more urgent and more carefully considered. I want to tell you specifically about the first week back, because the first week back had a quality I was not prepared for, which was the quality of the ordinary. I had expected the office to feel different, or to feel the same in a way that felt wrong, some dissonance between the before and the after. What I experienced instead was the specific normalcy of a space that does not know what has happened to the people in it and continues to function on the basis of its own logic. Files sat in their folders. The scheduling system showed appointments. My assistant had held all non-urgent matters for my return and had organized the urgent ones into a ranked list on my desk with the brief annotations I had trained her to provide. The coffee machine on the 4th floor still made the sound it had always made at 12 minutes past the hour when it ran its automatic descaling cycle. My office chair still had the slight resistance at the top of the recline that it had had since a modification I had requested 8 years ago, and that every subsequent engineer had failed to fully replicate. These things were as they had been. I sat in the chair, and I felt the resistance at the top of the recline, and I thought the chair is the same chair. This was both an entirely unremarkable observation and the most grounding experience of the first week. The conversations with my partners happened over the first 2 weeks. I had 2 full partners, both of whom I had known for more than a decade, and both of whom had the quality of professional loyalty that is built through the accumulation of shared difficult cases, rather than through any formal declaration of allegiance. I told them what had happened in factual terms. I told them what the legal proceedings were and would be. I told them what I intended to do about the firm structure going forward, which was to formalize the succession arrangements that I had been deferring for years, and that the October events had made it no longer possible to defer. They listened, asked specific questions, and responded with the professional competence and personal steadiness I had relied on for years. Neither of them said anything that was not useful. I valued this more than I could easily quantify. I also did something I had not done before, which was to see a therapist. A colleague recommended someone in Basel, a clinical psychologist named Dr. Kramer, who specialized in trauma and who had worked with professionals in crisis situations. I want to mention this because it is the part of what happened to me that I am most inclined to omit. Because the professional training that has served me well in most respects also includes a specific resistance to the acknowledgement of psychological difficulty, and that resistance is not always useful. What Dr. Kramer helped me understand over the course of a year of weekly sessions was that the platform in Lyon had made visible something that had existed for longer than one evening, which was the specific cost of having built a professional life of exceptional precision and reliability in a context that I had underestimated. I had been, as she put it, attending very carefully to the structure of everything I built, and not attending carefully enough to the question of who was inside it. Dr. Kramer was a small, precise woman in her late 50s who had a quality of attention that I recognized from the first session as professional in the same way that my own attention was professional. She did not perform warmth. She was warm, which is a different thing, but the warmth was structural rather than decorative, present in the way she organized the session, and in the way she asked questions, and in the patience she brought to the moments of silence when I had said something and had not yet understood what it meant. I had been in those sessions on the other side of something like this dynamic, sitting across from clients who were talking through things they were beginning to understand, and it was instructive to be on the other side. Instructive and uncomfortable in the specific way of accurate discomfort, the discomfort of a thing that is true and that you have not fully acknowledged, until someone creates a space in which not acknowledging it is more effortful than acknowledging it. What I acknowledged in those sessions over many weeks and in many small pieces was approximately the following. I had constructed my professional life with extraordinary care and maintained it with extraordinary consistency, and I had applied somewhat less of that care and consistency to the personal relationships that existed alongside it. Not from negligence exactly, but from the specific assumption, which I had never examined directly, that the quality I brought to my work would transfer automatically to my personal relationships, and that the structure I built professionally would also protect what mattered personally. This assumption was incorrect. The platform in Lyon was the most dramatic demonstration of its incorrectness, but it was not the first. I had missed things about Dominic, because I had been applying my professional judgment to someone in my personal life, and had then, when that judgment produced preliminary concerns, deferred to the personal relationship rather than the professional assessment. I knew how to trust evidence in a courtroom. I had been less consistent about trusting it at a dinner table. Dr. Kramer did not tell me this. She asked questions until I told it to myself. This was true about Dominic. It was also, I had to acknowledge, true about Isabel. Isabel did not face criminal charges. The prosecution made the determination that the evidence of her specific knowledge of the homicidal intent was insufficient to meet the standard for conspiracy, and that her cooperation had been too complete and too early to sustain a charge. She received instead a formal caution from the civil court in connection with her participation in the power of attorney fraud, which was a civil rather than criminal finding, and which had professional consequences for her, but not custodial ones. She was living in the apartment in Zurich alone in the months after the arrest. Dominic's assets had been frozen and subsequently attached to restitution orders in connection with the fraud case, which meant that the financial situation she found herself in was considerably reduced from what it had been. She called me 3 times in the first 2 months, and I answered twice. The conversations were not easy, but they were real in the way that certain very difficult conversations are real in a way that easier conversations are not. She said in the second of those conversations, "Papa, I want you to know that I am genuinely sorry. Not as a legal strategy, not because I need something from you. I am sorry because what happened on that platform was something I should have prevented and I did not prevent it, and I have to live with that. She said I am not asking for anything. I wanted you to know that the sentence was not a relief for me. It was the appropriate outcome. I said nothing for a moment. Then I said, that is the right way to understand it. She said, I do not know how to ask you whether there is anything left. She said, between us, whether you still have a daughter. I sat with this for a long time. I said, I do not know the answer to that yet, Isabel. I know that I am not going to answer it in a hurry. She said, I understand. I said, that is enough for now. It is, I think. Always enough to begin with what is honestly available and to let the rest develop from there, at whatever rate it develops, without forcing it into a shape that neither of us is yet certain of. What I want to tell you about the period after the sentencing is the thing that I find myself most surprised by when I reflect on it now, which is the quality of the work. The firm continued. The practice continued. The civil litigation work continued. The patient, precise work of building arguments and examining evidence and finding the fact that the other side has overlooked and that, when correctly placed in the sequence, changes the shape of the entire proceeding. This work was not therapy. It was not recovery. It was simply the thing I did, the thing I had done for 34 years, and its continuation in the months after the platform had a quality of normality that was itself a form of survival. I want to also tell you about a specific morning in February, 4 months after the platform, when I was in my Basel office at 7 in the morning, working on a brief for a pharmaceutical liability case, and my assistant knocked on the door and told me that my 9 o'clock had arrived 40 minutes early and was waiting in reception. I asked who the 9 o'clock was. She checked her screen. She said a new client referral, a Dr. Franz Haas. She paused. He says he is Dominic Haas's father. I sat with this for a moment. Then I said, please tell Dr. Haas I will see him when his appointment is scheduled. He came in at 9 o'clock. He was 71 years old, a retired physician from Zurich, and he sat across from me with the posture of a man who has prepared very carefully for a difficult conversation and is not certain his preparation is adequate. He said, Herr Westerberg, I know who I am, and I know what my son did. I am here because I was given your name as the most accurate and fair attorney in this jurisdiction, and what I need right now is accuracy and fairness more than I need sympathy. I looked at him. I said, what is the matter? He told me. His matter was not connected to his son's case. It was a property dispute involving a commercial building in Zurich that he had co-owned with a business partner for 20 years, and that the partner's estate was now attempting to value in a way that was materially unfavorable to him. It was a legitimate civil matter requiring competent legal representation, and he had come to me because he had been told I was the right person for it. I could have declined. I thought about declining. I sat with the thought for approximately 15 seconds. Then I said, tell me the facts of the situation, and I will tell you whether I am able to take the matter. He told me the facts. The facts were clear, and the matter was one I was equipped to handle. I took the case. I handled it well. It was concluded in his favor 7 months later. I tell you this because I want to be precise about what the experience produced in me, which was not forgiveness of what Dominic had done, which is not a thing I can feel, and not indifference to what he had done, which would be dishonest, but something more precise than either of those. A recognition that the structure of the work of determining facts and assessing their weight and building a case from what is real rather than from what is desired, does not change in character because of who is connected to the situation. I took Franz Haas's case because it was a legitimate case, and he had a legitimate right to competent representation, and because the alternative declining on the grounds of who he was related to. would have been a departure from the professional discipline that had kept me doing this work for 34 years, and that had, among other things, kept me alive on a Lean platform in October. The discipline holds. The work continues. The facts are the facts. I have spent 34 years making that phrase mean something in courtrooms and in settlement negotiations and in the late-night review of documents that will determine the shape of a proceeding. I intend to spend whatever years remain making it mean something in the rest of my life as well. It is a later education than I would have preferred. It is the education I have. I am writing this in my office in Basel on an April morning more than a year after Lion. The Rhine is visible from the window, the specific pale green of the Rhine in spring, a color that has been the background of my working life since I came to the city at 22 years old, and that I find I regard with more attention now than I did before October. Spring came again this year as it does. The window is open, and the air from the river has the cool mineral quality of river air before the city warms it. I want to tell you something about what I have understood from this experience that goes beyond the specific facts of what happened. Not wisdom, because the word suggests more resolution than I have achieved, but something more modest than wisdom and more useful, which is a more accurate assessment of the relationship between the professional and the personal in a life that has been organized primarily around the professional. I have spent 34 years building arguments. The arguments are made from facts, and the facts are verified, and the verification is the work. The work is what I do, and it is good work, and I am good at it. What the year since Lion has taught me through Dr. Kramer's questions and through the specific evidence of what I did and did not see in the months before the platform is that the same methodology that serves me in a courtroom also serves me in the rest of my life if I apply it consistently and not selectively. I had applied it selectively. I had applied it to my professional relationships and not to my personal ones, because professional relationships are explicitly contracts, and personal relationships are implicitly contracts, and the implicit ones felt. To a part of me that I had not fully examined, like they should not need the same verification that the explicit ones required. This is wrong. Relationships are structures. Structures have load-bearing elements and failure modes and tolerance thresholds. The ones that carry the most important weight require the most careful maintenance. I had been maintaining the professional structures and assuming the personal ones were self-maintaining. They were not self-maintaining. No structure is. The Swiss financial fraud proceedings concluded in February. Dominic received a separate sentence of 4 years for the financial offenses to be served consecutively with the French sentence. The total sentence was 18 years. He was 40 years old when he was sentenced. He would be 58 when he was released if he was released at the standard point. He had no assets. The debt was attached to the restitution orders. The firm continues. I formalized the succession arrangement in January, establishing a clear path for my two partners to acquire the firm over a 7-year period on terms that reflected the firm's actual value rather than the notional value that various parties had at various times believed it to represent. The process of establishing that arrangement was the most satisfying professional project of the past 18 months, because it required the specific application of the lesson I had been learning since Lion build the structure, correctly document everything, do not defer the difficult conversation. Isabel and I had dinner in March. It was the first dinner we had had together since Lion. We went to a restaurant I have been going to for 20 years, in the old city near the Münster, a place that does not try to be anything other than what it is, and that serves food with the specific quality of food cooked by people who understand the raw material. We did not talk about Dominic or about the platform. We talked about her work, a residential renovation in Geneva she had just completed, and that she described with an energy I recognized as the energy of someone who has returned to the thing they were doing before the distraction arrived, and found that it was still there waiting for them. We talked about my work. We talked about Basel in April, which is what it is. She asked at the end of the evening whether she could call me more regularly. I said yes. She said not to ask for anything. I said I know. She said I just want to be your daughter. I said you are my daughter. That is the one thing in this situation that is not in dispute. She said Papa. She said it with the specific inflection it had when she was 12 years old and wanted to ask something. She was not sure I would agree to the inflection that is almost always followed by something real. She said, I want to tell you something. I said, tell me. She said, on that platform, when he told me there had been an accident, when he said we needed to go. I did not go because I believed him. I went because I was afraid that if I stayed, I would see something I could not undo knowing. And I have had to live with the understanding that choosing not to know is not the same as not knowing. I said, I know that. She said, I know you know. I wanted you to know that I know it too. I sat with this for a moment. Then I said, that is the right understanding of it. She said, is it enough? I said, I do not know yet. It is more than I had 6 months ago. We had coffee after. The evening was cool, and the old city had the quality it has on spring evenings. The quality of a place that has been here long enough to be patient about most things. We walked back along the river before we said goodnight. The Rhine was doing what it does, moving in its direction without consulting anyone. I am 63 years old, and I am a civil litigation attorney, and I was pushed off a train platform by my son-in-law in Lyon on a Thursday evening in October, and I survived by falling correctly, and I had 6 hours of advantage over the people who did not know I had survived, and I used those 6 hours correctly, and the work continues. The spring is outside the window. The Rhine is the specific pale green it is in April, and it will be the specific dark gray it is in November, and neither of those things requires my opinion. That is the full accounting. That is all of it. The case of Franz Haas concluded in his favor 7 months after I took it. He sent me a handwritten note afterward that I have kept, not because lawyers keep letters from clients as a rule, but because the note said something I found precise, and therefore worth keeping. He wrote, I came to you understanding you had every reason to refuse. You did not refuse. I think this tells me something about the kind of man you are. I do not know whether to be glad or ashamed that I did not know this about you before you had reason to demonstrate it. I read this note more than once. I think it is the most accurate thing anyone has said about this period of my life.